Everyone, and good afternoon. My name is Mark Rotenberg. It's a real pleasure to welcome you to this panel and also to congratulate you because it's end of day, last session, and you're still here. So trophies for everyone. Nice to see you. We're going to begin our discussion on AI governance in just a moment. Thank you so much for getting that door. I did want to say just a few brief words about our organization, the Center for AI and Digital Policy, which has put together this panel, and also recognizing many participants from our organization who are here today. We're a global network of human rights advocates and AI policy experts, now in over 100 countries. We do training for future AI policy leaders, and we're very interested in the issue of AI governance. We've just published 2 big books, and I know that they're big because I carried them in my suitcase from Washington last night on the plane, and my back is still hurting. We have a book called the AI Policy Sourcebook, which is the essential governance frameworks, which includes, by the way, not only the EU AI Act, but also the UNESCO recommendation on AI ethics, the Council of Europe AI Treaty, the OECD AI principles. We actually have a whole section on the White House executive orders. You may have heard we've had a little change in administration in the U.S. recently. We're following that just a bit. There might be 1 or 2 changes in national policy, not sure yet. But if you're interested in AI and what's happening in the U.S., we have some background materials. And we also publish this now 2-volume set called the AI and Democratic Values Index, which is a comprehensive review of AI policies and practices worldwide. We actually rate and rank countries based on their alignment with a set of metrics that we've identified as aligned with democratic values, broadly understood. So I'm providing that little bit of background, and again, these resources are available to you online. If you're here for this session, you're likely interested in AI governance, so we're very happy to make these materials available to you. But of course, what's so wonderful to be in Brussels in early 2025 is the obvious importance of AI governance in the EU, and in particular where we are with the EU AI Act, the related GDPR, the DSA, the DMA. And for this conversation, I really couldn't imagine a better panel of diverse viewpoints and perspectives to help us understand where we are with governance in the EU, with a particular attention, I would say, in this moment to fundamental rights. Were fundamental rights adequately addressed in the Act? What do we anticipate going forward? There's quite a bit of controversy, I know, about the Code of Practice. And what I'm going to propose is to really do this panel more as a conversation than as a set of set pieces. And I'm going to ask each of the panelists to briefly introduce themselves, say a bit about what they're doing on the AI governance front, and then we'll begin a conversation. And we'll talk about what's been accomplished, what some of the challenges are going forward, leave some time, invite you to participate. So with that bit of background, Anne-Charlotte, if you would like to tell us about the work of the Belgian Data Protection Agency.
Sure, thanks, Mark. Well, first of all, thank you for having me. Thank you for, as Mark said, thanks for still being here as the last panel. So I'm a board member at the Belgian Data Protection Authority. And well, yeah, I'm particularly happy to be here at this pivotal period of shaping the regulation, the future regulation of AI in Europe. We all know it's a landmark, the AI Act is a landmark legislation, like globally. The aim to protect fundamental rights is something that is very important to us as a data protection authority, of course. And yeah, in that quality, we believe we will have, or at least we should have a crucial role given the very inherent links between personal data, data protection, and AI systems. But I'll get into that later when we'll actually talk about the role of DPAs. I'm sure we'll also touch upon the challenges ahead of us, because of course it's not going to be smooth. There's going to be many challenges to overcome, but this is also why I'm happy to be part of this panel, as I'm sure it'll be very insightful, the conversations with the other panelists and with the public, to get the best way forward for all. That's it for me. Maybe you want to take over?
Hi, everyone, and it's great to be here on this panel, and great to see you all as well. My name is Julia Apostle. I'm a private practice lawyer with the law firm Orrick. And despite the Canadian accent, I have been working in Europe for the past 20 years or so, give or take, on freedom of expression, media, and now digital tech issues from many different perspectives. Orrick is a firm that is primarily focused on tech and tech clients. And in my practice, I have the privilege to advise clients of all sizes, from small startups of 2 people to large multinationals from all geographies, and also NGOs and charities on these issues, right? So compliance not just with the AI Act, but also with every other single tech regulation, of which there are many that cut across the AI Act. So they have a particular perspective on that, and also have been working on the implementation of this legislation and the Code of Practice.
Thank you very much. My name is Karolina Iwańska, and I work at the European Centre for Not-for-Profit Law, ECNL for short. We are a civil society organization working to protect and promote civic space and civic freedoms. We are also a member organization of EDRI, that many of you probably know, European Digital Rights. And we have been quite actively involved in the negotiations of the AI Act, but also the Council of Europe Convention on AI. We are now in the very deeply in the process of the implementation of the AI Act, and our areas of focus include issues around biometric surveillance, but as well fundamental rights impact assessments, the issues of national security, because we are very unhappy with the broad blanket national security exemption that the AI Act has. And as part of a coalition of organizations during the negotiations, we were advocating for strong protection of fundamental rights in the AI Act. It is a mixed bag. The AI Act is definitely constitutes a good starting point for transparency and accountability of AI, but it is packed with loopholes when it comes to fundamental rights protections. And we definitely do not see it as a golden standard that other countries should aspire to put it bluntly. And we think that implementation will be crucial to fill some of these gaps and to ensure the strongest possible understanding and interpretation of what is in the AI Act. And I think we will get into the details of where we are about this at this moment in time.
Let me say, by the way, for people who are coming in now, there are actually quite a few seats here, so if you'd like to grab a seat, maybe you're able to do that. Wonderful, thank you.
Thank you. My name is Gregory Lefkovich. I'm a professor of law and technology at the Université Libre de Bruxelles. So I'm the director of a research group called the Smart Law Hub. We are following up on digital regulation and policies, but also, I mean, we were always convinced that we need to have more and more interdisciplinary work between computer scientists and lawyers. So we have also a team of developing and using machine learning for law, trying to develop also metrics to evaluate models and respect for fundamental rights in this context. Probably for this reason, I was recently appointed the academic director of AI for the Common Good Institute in Brussels that bring together 350 researchers coming from law, technology, robotics, and trying to work to work together, even if it's not always easy to translate what are the concerns of all the different expert profile disciplines. And I'm also a member, delegate, one of the delegates for Belgium in the AI board. So, you know, this organization, in this forum created in order to ensure, and we will see if it works, a kind of common interpretation of the AI Act for implementation in the different member states, because that is, of course, probably one of the crucial aspects if we want to have some kind of impact with the AI Act. And I'm really happy to be here. Thank you for having me.
Great. Well, thank you all. I want to begin maybe by establishing a bit of foundation for our conversation. Certainly there have been concerns and criticisms raised about the AI Act. But if someone were to ask the question, you know, what are the primary accomplishments? What was achieved with the enactment of the AI Act? How would you answer that? Maybe I'll start with Julia. What's your answer to that?
Getting it adopted, I think. I mean, as a starting point, which now in the current context seems even like more of a feat. And the fact that it is moving forward, I mean, there's talk of delays and so forth, but the fact that it is moving forward for better or for worse. I mean, I'm still, split on as to whether, the pace is the right pace. But the fact that it is still going and that there seems to be some entrenchment in moving forward with it, notwithstanding a sort of geopolitical environment that is anti-AI regulation, is an achievement, whether that's a positive or negative achievement.
And I think you're saying also that trying to get it done now in this political climate would actually be more difficult, than over the last few years.
I don't know, because I mean, I think that maybe the camps are even more divided. Like, I think the nays are probably, now that there has been more visibility on what it would look like, what AI regulation, what it entails. I think when it got passed, it was still, it was still quite new, and what an act should do, what regulation should accomplish was not, it wasn't on the agenda as much. Now I think the discussion would be completely different. And would that bog down the ability to actually get it done? Potentially, except that there's also a perception that we really need regulation,
Right.
In the absence of anyone else moving forward with regulation.
Let me ask you, Caroline, I know your organization was very much involved in the debates over the remote biometric identification and the various AI systems that should properly fall in the prohibited category. And just to remind people, you use this phrase, risk-based framework, to describe the AI Act, but it's very important to know that in this risk-based framework, that top tier are systems that simply should not exist. And I guess my question to you is, if you had the opportunity to get more AI into that prohibited category, what would some of your priorities be?
Yeah, I think definitely the category of prohibited AI practices is a huge win for civil society, because I don't know if you remember, but in the first draft of the AI Act that we saw, there was no such category. And it's thanks to advocacy from civil society that policymakers recognize that there is a category of systems whose impacts are simply unacceptable in a democratic society. My biggest issue with the list of prohibitions that we have after the process is that it is full of exceptions. So my change to that list would be to plug these gaps. For instance, when it comes to real-time biometrics, remote biometric surveillance, the only type of system that is prohibited are the identification systems that are happening in real time and only for law enforcement purposes, which I think is all the rest are considered high risk. And I think this is a very fake distinction because the risks associated to retrospective biometric identification are exactly the same for fundamental rights. From the perspective of fundamental rights, it doesn't matter if I am being targeted by biometric surveillance on the spot or 5 seconds after or 3 days after or a week after. We were even arguing during that process that actually the risks even increase in retrospective context because you can plug in more databases to compare people to. So that is definitely a criticism, something that we have been advocating for. ECNL is also part of the Protect Not Surveil coalition, which is a coalition of civil society organizations working on AI and migration and criminal justice. And the fact that there are absolutely no prohibitions in the area of migration was a political choice, right? It wasn't the fact that these systems do not have the same unacceptable fundamental rights issues. It was a very politicized debate in the current sort of anti-migration climate that led to lack of any prohibitions in that area. And similarly, when it comes to emotion recognition, it has been prohibited only in 2 areas, so in workplaces and in education, while we have documented cases of using emotion recognition at the borders, for instance, where that leads to huge human rights concerns and violations. So I think these kind of loopholes that we are already actually seeing in practice, if I may just add, one specific case that we have seen in the last few weeks that maybe some of you have heard about is that Hungary is deploying facial recognition during protests, during the prohibited protests, including the Budapest Pride. And I think this is exactly the situation that the AI Act, we were hoping that the AI Act would prevent, because there is a big debate now whether that system will be real-time, whether it will be retrospective, despite the fact that the police will have direct access to the sort of comparison software. Hungary is using that argument that it's not prohibited, so it's not even kicking in yet. It will only kick in 2026, the obligations for high risk. And this could have been easily prevented by not creating this sort of double standard when it comes to biometric surveillance. And one last thing that we tend to forget about, and I already mentioned in my introduction, is the blanket national security exemption. Mm-hmm. That is very concerning because that essentially allows member states to bypass the whole of AI Act, the prohibitions, the kind of accountability rules, the assessment of fundamental rights impacts, just by invoking national security, which is a very vague concept. It's not fully defined. There is a huge opacity of when national security is invoked, so we are worried that it's going to be used as a sort of excuse, essentially, to escape responsibility.
Right. Thank you. Those are great points. And speaking of facial recognition, maybe we can come back and also talk about some of the cases involving Clearview, where I know the EU DPAs have played an important role, actually prohibiting the use of that service. And Charlotte, I'm fascinated in the EU AI Act, the process of designating the supervisory authorities, yes? This has not been simple because, of course, the member states have multiple offices and agencies that want to have some oversight authority. The last time I checked, I think there were 186 supervisory authorities for the 27 member states. And the list is still growing. But, of course, the data protection agencies are, for good reason, maybe out in front. People recognize the foundation of the GDPR, as we talk about the AI Act. So I was wondering if you could say a bit about how you see the role of the DPAs in the oversight of the AI Act.
Sure. Thanks, Mark. I think I'll focus mainly then on MSAs, so market surveillance authorities, because they'll have, although as you said, there's many authorities involved in the supervision and enforcement of the AI Act, the MSAs will have the biggest chunk of competences in the enforcement. And well, member states have a bit less than 3 months now, because the deadline is on 2nd of August, I believe, of this year, to appoint and notify the MSAs to the EU Commission. So, yeah, of course, us as a DPA, we're convinced of the fact that we should have a very leading role in the enforcement of the AI Act and that we should be appointed MSA. There's many reasons for that. Well, first of all, logically, the very strong and inherent links between personal data and AI systems. Most AI systems will involve, at some point at least, processing of personal data. So, and the AI Act is very clear about the fact that if personal data are being processed somewhere along the life cycle of an AI system, well, then the GDPR is applicable, also for mixed data sets. So, it also actually specifically states, I think it's Article 2.7, I'm not sure anymore, that the AI Act is without prejudice to the GDPR. So it's plain and clear. AI Act is not a lex specialis, but it's, the AI Act is not a lex specialis compared to the GDPR, but they're complementary to each other. So since personal data are so intrinsically linked to AI system, well, we see that it could be dangerous that DPAs are not heavily involved in the enforcement mechanism, because this might bring about lots of contradiction and potential difficulties in collaboration between regulatory authorities. So that's just, I would say, what I consider at least as the main and the most logical reason why DPAs should be given by governments a leading role, like a role as an MSA in the enforcement of the AI Act. But then there's many others. We briefly touched upon the decisions that have been taken by DPAs even before the AI Act involving AI systems. We mentioned Clearview, so facial recognition technologies. We mentioned also the decision by the Hungarian DPA when the government is willing to use facial recognition technologies to recognize participants in public protests. But there's many others. I mean, data scraping by AI system, by the decision against Casper, by the CNIL recently. The Belgian DPA has been taking a decision with regards to AI system measuring noise pollution. So there is that experience within DPAs in enforcing, both at international level, but also at national level, in enforcing in cases where AI systems are involved. And then on top of that, there's many other reasons as well. I mean, the AI Act is very clear about the role that needs to be given to DPAs. I mean, for Annex 3, part of it, the AI Act clearly says that DPAs need to be involved. So for Annex 3 high-risk systems, it's very crucial. Also for sandboxes, Article 57 is very clear that as soon as personal data are being processed, the DPA should be involved in the sandbox. And also maybe my last point, the last reason why it only makes sense that DPAs are MSAs, or at least heavily involved in enforcement, is simply because the AI Act reflects so many principles that are fundamental to the GDPR. I mean, explainability, human in the loop. This obviously echoes Article 22 of the GDPR, so the right not to be subject to an automated decision-making, and also Article 15 of GDPR, so right of access. The AI Act also strongly emphasizes the quality of data, particularly for a high-risk system. Well, this obviously also builds upon and echoes the principles of data accuracy within the GDPR. Of course, all the articles about bias mitigation and discrimination, they also strongly link to the principle of fair processing of Article 5.1 in the GDPR. So there's so many links. And then again, the measures for mitigating risk, I mean, between a DPIA and a FARA, there are so many similarities that we only see reasons why the DPAs should be MSAs, or at least have a very important role in the enforcement of the AI Act. And so for what regards Belgium, well, the negotiations are still ongoing, as in many European states, I believe. We're a fundamental rights agency, but we don't know yet if we'll be an MSA. But we're hoping that there'll be awareness at the political level of all the good reasons, all the important reasons why the DPA should be MSA.
That's great. Thank you. Thank you so much. Gregory, I'm hoping that you can give us some technical insight into how this debate is evolving. And I have to say, coming from the US, it's really quite striking. I mean, we have the doomers, the tech experts, who say, you know, that AI is going to rule the world and we're going to be turned into electricity or batteries or whatever it was in the Matrix. But the same people also saying, you know, we need to race ahead and cure cancer and move to Mars and whatever else they have on their bucket list. What's your perspective here in the EU? What is the view of the technical community, the academic world, the business world?
On AI or the AI Act?
Well, let's do both.
Okay.
Whichever's more interesting.
So, for what I know in the academic communities, if we start to talk about computer scientists and people that are developing, there is a lot of people that do not believe. I mean, I would say in Europe, the majority of people that I know are not buying the end of humanity and existential risk because of superintelligence. But you have some fear of catastrophe because of normal accidents. The point is that if you have more and more infrastructures that are relying on machine learning model or even, in fact, even softwares that are not perfectly done, tested, etc., you may have very huge accidents, not because of superintelligence, but because of bad coding, bad modeling, bad machine learning model, bad testing, etc. And that is something that I think is, taken seriously for a lot of people on the technical side. I think that the AI Act is, to a certain extent, is building on this perspective, not of the apocalypse, but more like how are we going to prevent, but I will give also a little bit my interpretation of the thing, is how can we prevent to have with AI systems what we have for normal software? Because if you take normal software, we have decided that we will not regulate software, only rarely, like avionics, etc. But other than that, there is not so many rules. While we have a market failure there, we have a market failure because nobody can evaluate a software. When you buy it, you buy it. Some people will show you some magic, but you cannot evaluate. And we are buying software for a long time. And cybersecurity is just the price we are paying because of basically market failure. So with machine learning model and AI systems, you still have the same kind of market failure, but there the software is not there for only support, but also for strategy. So decision making. And there, the risk and the cost of the market failure can be fundamental rights. So then you need regulation to prevent that. And I think that's the approach of the AI Act. That is not perfect at all at the same time, because it's a product regulation. From this perspective, it's quite different from GDPR, because the goal is first and foremost to build a single digital market. That is the idea, and it brings this novelty. It is more like a puzzle, is how can we protect fundamental rights in the context of a product regulation. And I think that there is a lot of dangers, but there is also, from the academic perspective, there is a lot of juice in that, because there is very complex questions that you need to address and think again. Last thing that I would add regarding on the academic side is what I think is very problematic is that even if we have no regulation on data, AI, content, because also we have Digital Services Act that regulate content, that is also to a certain extent data. So all that, even if we have all that, it seems that we did not push the legal community and policymakers have not pushed enough the topic so that the training of computer scientists has changed. If you look at the normal training of a computer scientist, people that will do machine learning tomorrow, most of them have no clue about fundamental rights. And as long as we cannot change that, we can bring whatever policies, rules, etc., it will have very little impact.
It's a great answer. I'm actually going to come back to the entire panel about how AI is changing, because I think it's actually in the changing nature of AI as we move from deterministic systems to machine learning and probabilistic systems, the fundamental rights issues become more critical, not less. But we'll come back to that. Before moving to that conversation, I wanted to throw out a general question to the panel, and I would appreciate your insight on this. You know, I remember when the GDPR came about, and there was a professor at Columbia Law School in the US in New Bradford who wrote the book, The Brussels Effect. She coined the phrase, actually. It was a very influential way to think about the role of the EU in the global economy and global markets. And clearly the GDPR has had a global impact. I study this, I see laws that look like the GDPR in Brazil, Saudi Arabia, China. I have students from China in my class at Georgetown, and they compare their personal information protection law with the GDPR, a lot of overlap. So no doubt that if we were talking about the GDPR, we see the demonstration of the Brussels effect. And I guess the question I wanted to throw out to all of you is, do you anticipate with the AI Act that we will also see a Brussels effect? And Julia, maybe I'll start with you since you have a broad practice.
And I have been thinking about this, and you know, the GDPR applies to all personal data, broadly defined and broadly interpreted. The AI Act does not apply to all AI. So that's a huge difference, because to the extent that, you know, there will be AI systems where you're completely out of scope of the AI Act, then there is no gold standard or there is no framework, and therefore there is scope to create a different framework and a different regulation. And I mean, deployers and deployment of AI is not heavily addressed by the AI Act. We know that most of the obligations fall to providers, and it's much more vague, except when it comes to, you know, prohibited AI. You know, there's prohibited uses. Deployers do have some obligations under the AI Act. But it's a little bit more vague when it comes to the value chain, you know, and downstream modifiers and downstream providers. And so deployment remains an area where, you know, some other country can, or individual state within the EU or individual state within the United States can come in, and they are coming in with sectoral legislation around use cases. So I'm not sure that the AI Act will actually therefore have the sort of same Brussels effect, just because the reality is that it's not all consuming.
What do others think? Do we anticipate a Brussels effect?
I would say it's already there because the risk-based approach is already followed by the Council of Europe Convention on AI. There was a peculiar, during the negotiations, the AI Act was being finalized, and the EU had a very strong influence on the final shape of the convention. And also Canada, for instance, had a similar approach. I think the risk-based approach is already the Brussels effect that we are seeing in other countries that are also regulating AI, and I don't think it's necessarily positive, because the thing is that in the EU, the pitfalls of the AI Act, of the loopholes of the risk-based approach are mitigated by the fact that it is based on a strong foundation of the Charter of Fundamental Rights and of the data protection legislation, that is a rights-based legislation. And my fear is that many countries will be replicating the AI Act without having that foundation. So without necessarily having mechanisms in place that can basically address the gaps, address the the issues that we have with the AI Act. So, and I think a lot also about the positive, perhaps, Brussels effect will depend on how well the AI Act is implemented and enforced. I would not, I would be remiss if I didn't mention the strong push for deregulation at the moment in the EU, to which AI Act might fall victim. I think everybody anticipates that something will be done with the AI Act in the coming months when it comes to the deregulation agenda. And so the question is, to what extent the AI Act will actually fulfill the promise of protecting people's fundamental rights. So I think, the world is looking at the EU to see, how the AI Act will be implemented in practice, whether we actually prevent fundamental rights issues. And I'm not, to be honest, completely honest with you, 100% confident that it will. So in the current deregulation debates. So this is something that worries me, and I worry that instead of, potentially positive Brussels effect, we will actually work with partners around the world to prevent their governments from following the lead of the EU on this.
And we raised this point earlier. If you export the risk-based approach without an understanding of prohibited categories and without a commitment to protecting fundamental rights, it really turns out to be a fairly weak model for regulation. Thank you.
Thanks, Max. I just wanted to maybe build upon what my colleague just said here. I believe that as long as it's fit for the local context, it is good that there is a regulation around AI, of course, but again, not a replica, but that it's adapted to the local context and the local needs. I think what's also very important is something that we touched upon earlier, and it applies here. It's the importance of fostering a culture of awareness around fundamental rights in AI systems. So as long as this is done hand in hand, then I'm happy for that to be an expansion of AI regulation globally, and not just mainly in Europe as we're seeing now. Yeah, so I'll stop here.
Yeah. So I think that for what I know there is already, of course, a lot of discussions in different countries. I was discussing with people in Japan, looking heavily on what is the AI Act, what is the idea of regulating large language model and more generally generative AI. That was discussing also with people from Saudi Arabia. But everybody is looking at this piece of regulation with the question, will it work? Will it work? And this is not completely clear, especially because inside Europe already, there is a lot of people that are criticizing, claiming using the usual innovation regulation game, we have a regulation that is not yet completely enforced, will not be enforced, and already we imagine that we have to change it. That is not a very confident approach. So that's one aspect. I think there is another aspect that maybe will prevent the AI Act to have exactly the same impact than the GDPR, is that it's a regulation about products, and these kind of products are not made mainly in Europe. Even if when you have pieces of or part of a software that are made in Europe, they have to connect with other part of software that are done somewhere else. You need to integrate in systems that are not made in Europe, not only in one country, but everywhere. So it's a global industry. And from this perspective, if you want to still have a digital ecosystem that works to a certain extent, what you will need is global technical standards. And in this discussion, because of course in Europe, technical standards will be very important for the interpretation of what the AI Act really means, at least for a producer, and of course they have most of the obligations. So what will be the room for a very specific voice of let's say fundamental rights people in this world of technical standards, where the decision will be taken. And I think that there is some people saying, okay, but the AI Act in the end is just deciding that the concrete rules will be decided in standardization organization where you have mainly companies that are mainly Microsoft, actors of the producing software. So the companies that are able to be there are mainly producer of softwares. So they are deciding and voting how we are going to concretely implement the obligations of the AI Act, and there is a danger for the role of law and the legal community, because maybe before everybody is completely understand what's going on, it will be too late.
Great. Thank you. Well, I'd like to turn the discussion now from the focus on regulation, which is, I think, a familiar conversation, to the technology itself. Because I think the way in which AI is changing also impacts fundamental rights, and we need to understand this. And just by way of background, I'll say that a very long time ago, I used to do computer programming, and I wrote chess programs and backgammon programs, and it was all very simple stuff. These were basically rule-based expert systems, decision trees, right? I see people nodding, and you know what I'm describing, because you could automate a decision process. And if you were writing a chess program and the knight spent too much time on the side of the board, you change the coefficient, the knight would be better placed, you'd win more games, better program, problem solved. We're in a very different world today. These are enormous data sets. They produce probabilistic outcomes. The outcomes are very impressive. I mean, we look at a sonnet that Shakespeare could have written but didn't, right? And thank you, Claude, for that. But we can't prove these outcomes. We can't reproduce these outcomes. We're simply left with a result. And even the programmers are saying, I don't know how this happened, right? People like Stuart Russell, very famous in the AI world, have actually said we need to move beyond simply regulating in the market, which is what the AI Act does, to regulating at the foundational level. Here are some terms which maybe you've heard. I find this a bit scary, kind of like Black Mirror. But if you want to know what AI programmers are seeing in their models, they use these terms. Deception, concealment, power-seeking, and self-preservation. Now, none of this is to assign cognition to a machine. It's simply to say that if you have an ambiguous goal, like be able to solve future problems, but I'm not sure yet what those problems will be, an AI following that instruction might start attacking power centers so that it has the power resources to solve a problem in the future that it receives. Okay, there's your little intro to scary AI. Now, what does this mean in practice? I was really intrigued by a decision a few years ago from the Court of Justice of the EU on the PNR directive, which I think many of you are familiar with. And a lot of your center and others were very concerned that this directive was a form of mass surveillance because passengers were subject to this kind of profiling. They hadn't done anything wrong. And you objected to the directive, which the court ended up upholding. But the court said this was okay because all the criteria that were being used were assigned by people. This was still under human control. But the court said if this was a machine learning system and the machine sort of reasoned to itself, these nationalities are more aligned with public safety risk. Therefore, the machine, will change the weightings to assign greater weights to those nationalities. The court said, no, that couldn't happen. So moving our conversation, let's say from the Article 22 GDPR frame, which is the old style expert systems, let's make sure these decisions are fair, to this new super impressive outcomes, but we don't know if they're fair, right, or just world. What are you thinking about? What do the policymakers and the lawmakers need to do to get ahead of this?
It's great that you brought the PNR ruling because I was just checking it when you were asking your question because I think this is a very important ruling in this context. Because essentially, and I think that emphasizes the point I made earlier about how, any use of AI in the EU and the AI Act are underpinned by fundamental rights. And not only the rights that we consider sort of the most obvious ones when we think about AI, like the right to privacy, the right to data protection, non-discrimination, but also procedural rights, the right to good administration, redress, transparency. So essentially, whenever the stakes are high, and I think that's how I understand the Court of Justice ruling, when a system is involved in making a decision that impacts your life, it has to be, the decision has to be justified because the public body has the obligation under the right to good administration to explain the decisions that it makes about you in an understandable way, to be able to seek redress and so on. So in a way, any technical development to me is secondary to that. So it might be, and actually, many computer scientists already emphasize this, that some types of AI systems are simply should not be used in making decisions about people. And I think, this is important for us to consider, that we are not in this sort of like technical determinism and that, that we have to use these systems. So we still have agency as policymakers, as people, as deployers of these systems. We have the legal rules that sort of create the boundaries of how we're going to use them. And I'm very glad from this Court of Justice ruling because I think it emphasizes very much that we have rules that underpin these things, and if you cannot guarantee a due process, then maybe you shouldn't be using that AI system in the first place.
And there are actually two subsequent rulings in Schufa and I think Dun & Bradstreet, Austria, yes. The court is basically saying, there has to be a meaningful assessment of how that decision was made. And the corollary, which is really important for our conversation, is if you can't provide that meaningful assessment, you can't use the system, right? So what do you think, Julia?
I think, when I read these decisions, what I think that we have under-focused on in law, and I'm not more broadly because I know it's a whole area of study, but what is becoming more important in the legal space, in which, as a practitioner, touch on but don't delve into, is this whole concept of decision-making and how decisions are made and how human decision-making translates into technical decision-making, and how that then has to feed back into how do we capture in legislation the complexity of legislation, which is, a human process. Decision-making is at the start a human process that's then been taken over or, captured in software programs, and then we have to draft laws to then control the software programs that are implementing a human process. And I suppose it's very convoluted, but I don't think there is a satisfactory solution to that. And I don't necessarily read the Schufa judgment saying, oh, they nailed it, or that's a completely correct assessment of how, how the law should approach automated decision-making as it gets increasingly more complex. It solves one solution or it solves one problem in one instance, but this is going to be a much bigger problem, and we need to get much more sophisticated, I think, in our discussion around what is decision-making, period.
Yeah.
So
Agree. Gregory, you had made the point earlier that, we rely today on a lot of software that's very complex and we really don't understand. But don't you see this problem getting exponentially worse in the AI era?
Yeah, so I think that the problem, yes, it's exponential because we use more and more complex model to take decision. And basically the IT, that was something that 20 years ago was in the basement of the company, is now on the top floor. And that is the evolution that we can really see in the building, in the banks, in the financial services. It's very clear. 20 years ago, people doing IT, they were in the basement. Nobody cares about these people. They're just dealing with the tubes. So at the same time, I want to say something in favor of machine learning. Of course, it's probabilistic, etc., but we have a bunch of evidence that, especially when we have to take complex decisions with a lot of parameters, etc., we have a lot of examples where machine learning models are better than human, are performing better. They're performing better for a lot of stuff. When you have to take decision regarding cancer, regarding, it's a very important decision. But there was a publication, they were going through 327 publications, measuring performance of machine learning model versus human alone, plus machine learning, model, etc. And most of the time, the machine learning models that were correctly trained for a specific purpose were better than humans. And when you add humans, the decision is not better. So I think that we need, on this point, we need to be also aware that we are already living in a world where a lot of things in the infrastructures are working with machine learning models that are used and that are providing us with very useful service. So then when we start to discuss about it, that's where I think you're completely right, that we need to get a little bit deeper into what it means exactly to take decision, how it works, because we know also that humans are potentially biased sometimes. So you have machine learning models that are biased. You have humans that are biased. So how we can use both in order to maybe take the best decision that we take, that we can. And of course, when we say on one side we have machine learning models that we do not understand, at least sometimes. We don't understand the predictive model. We know exactly how we have produced it. We just do not understand always all the parameters because it's very complex. Let's discuss about ChatGPT. Close your eyes, think about a 1,000 dimension space. That starts to be a very, very complex for us. So, but we know how theoretically it works. And on the other side, we say, and then we have decision-making. In decision-making, humans are transparent, sharing arguments, etc., etc. At the same time, we know very well that what people are saying is not necessarily the way they are deciding. Right. So you have the context of discovery and the context of the justification. The justification of the judge does not explain how he reached the decision. Just explain the justification for the decision he has taken, knowing that he is under the scrutiny of a lot of people that will potentially disagree. So you make a strong argument for your justification. And I think that's a very fantastic model that we have in the judiciary. But it's so to really identify where it's better to do what. I think it's very crucial to have a more careful approach to this question.
What else? I mean, I'd say many people are not aware of the decisions they're actually making. And that's what AI is forcing us to become slightly more conscious about. It's like, I didn't even realize I was making a decision when I did X, Y, Z, but the programmers know that this is a decision that gets made. And I think, and I see all the time in companies and advising clients about their compliance and how they implement their compliance and what those compliance points are. It's generally when decisions have to be made, and companies don't even necessarily know when a decision is being made that has significance, right? So you have to help companies understand this is a significant decision that brings in the application of law, and these are the consequences of those decisions. But that's not a natural thought process, and I think it's a thought process that we all need to get better at it, being sort of more aware of decision making. And in the Schufa decision, I did a decision a lot. It was the court that said, "Oh, this is where the decision happened, not here," right? And it's just like, you know, I find that quite interesting to actually say you thought you were making a decision, but you're not making a decision, and we have decided the decision got made somewhere else. And I think we need to sort that out in relation to AI.
That's very interesting. We're going to open up for questions. I'm going to end with our DPA reassurance that you're going to be able to manage all these problems. I just wanted to pick up on one thing that Gregory said about AI making better decisions. We certainly experience that in the chess world. chess programs today are far superior to human players. There was a period of time where people believed that somehow humans and machines working together would produce the best moves. That turned out not to be true. You basically had to remove the person because it was bad information in the ultimate decision. But the unsettling part of the story is that chess programs produce better moves, provably, but we don't know why, right? And you can imagine scenarios where, governments are trying to decide, do we go to war, do we this, do we that? And you've got these super smart machines that may have produced better decisions in the past than people. Do we rely on these machines not knowing the reasoning, right? And I know someone's going to come back and say, well, the big thing now in AI, is explicating reasoning. But even this is kind of an open thing. But you guys are going to solve this, right? Because you guys are like, you're like, Supermen with capes, flying through the world and bringing these machines to task. Is that our future?
I
Fingers
promise
crossed.
we'll do our best, of course. But if you allow, I just wanted to build up a bit on what Gregory said before when Gregory mentioned the ever more complexification of AI system use and the fact that AI systems are being more and more used in our daily lives and also in very important decisions, like, for instance, law enforcement, then it's getting really critical. And then before that, you basically mentioned the black box concept. So all I want to say about this is that the importance of the principles of transparency and of human control, so human in the loop in the AI Act, which also come from data protection, are going to be principles that we are really going to need to insist upon in the enforcement of the AI Act. And then also regarding the Schufa decision and also the Dun and Bradstreet decision, as a data protection professional, I'm very happy to see the European Court take this kind of positions, because then it's like the Dun and Bradstreet decision once again highlighted the fact that right to explainability already existed. We didn't need to wait for the AI Act for it to exist. So we're hoping that data protection will keep on being considered such an important fundamental part of the AI enforcement.
Great, thank you.
Yeah.
Okay, we have a bit of time now, actually. Happy to open it up if we have some questions for the panel. You just want to raise a hand, maybe? Colin in the back, I recognize you. I'm not sure, but I'm sure you're...
There is.
Oh, we do have a mic. Good.
Colin Bennett from the University of Victoria in Canada. I've been wanting to ask this question all conference. Generative AI systems like ChatGPT can produce a lot of really, really inaccurate information about individuals. So how does that intersect with data subject rights under the GDPR? And most explicitly, if that inaccurate information does real reputational harm, recalling Google Spain, etc., is there a right to be forgotten for Gen AI systems? And if so, how can that be enforced?
That's a simple question.
Thank you, Mark.
Thank you for that. Would someone like to take that easy one?
Well, maybe I can start with an easy part of the answer. Well, precisely the difficulty to follow up on data subject requests has been one of the main infringements that have been found in diverse decisions of DPAs involving AI systems. So it's something that's going, I don't have an answer, but clearly it's one of the, next to legal basis, transparency, automated decision-making, following up on data subject rights is clearly going to be one of the main issues at the data protection level, at least, that we're going to be confronted with. Yeah.
Anyone else?
Will automated data protection?
Great, thank you. Do we have another? Yes, sir, here.
Good afternoon. My name is Torsten Wetzing. I have a question for the Belgian DPA. We heard about the AI Act and exceptions for national security and your hope that, data protection will be on the forefront. And I wonder, from the Belgian perspective, how many data protection authorities across Europe have an explicit remit for national security as well, because we know that there are a lot of AI developments in the national security world, and I hear in some countries there's backpedaling, that the remit of data protection authorities will no longer cover the national security intelligence space. So if there's a perspective on you, how many of your colleagues have a remit on national security, and that should also include AI in that space? I'd be grateful for a comment. Thank you.
Well, maybe I can start by answering that because we're in Belgium. Well, we have many authorities for many things. So as a federal DPA, we're actually not competent, for instance, for national intelligence services. So it's not even us handling these, the data protection issues on that level. But then with regards to what's happening on the political level, it's still going on. So I won't be able to answer that question for now.
Monique? Can we get a mic forward? No.
Okay. I also wanted... Okay.
Okay.
Andreas Heuselmann, Open Universiteit. Julia, you've mentioned like the aspect on how decisions are being made. And now my question is, how do you see the right to explanation under the AI Act? Because there the text clearly indicates the role of the AI system in the decision-making procedure. And also if we compare it with Article 22 GDPR, this decision doesn't necessarily need to be fully only automated, but I think, the question is, does the right to explanation under the AI Act maybe contribute to like the more attention to the decision-making procedure?
It'll focus yes, because I think it's probably a little bit broader than the decision-making requirement under the GDPR, but it'll be focused on the AI system and the decision of the AI system. And I think what we want to ideally make sure it captures is the more holistic decision-making process, because I don't think the decision necessarily starts and stops with the output. Yeah?
So I think there are ways to think about transparency of decision-making as in the individual aspect, and that's where the right to explanation comes in. But I think where AI Act can be actually quite promising is the explanation of the system itself. So we have Annex 4 that to me has a lot of comprehensive information about the system, the rationale, the assumptions, the trade-offs. It's actually a really good annex. I really like this one. The problem is that not all of it will be published, which is an issue for actually keeping systems accountable. And then on the provider side, the risk assessments, and on the deployer side, the fundamental rights impact assessment. This is yet another moment, an opportunity to examine, okay, where exactly decision will be happening, what parameters are taken into account, how does the whole decision-making process and human oversight, how does it work? So I think this element of explanation towards the individual affected is definitely important for the individual right to redress and so on. But I think there are many other points in the development and deployment process where there are moments to interrogate the AI system of how decisions will be made. So not only at this very, very end, as you say, at the output.
Yeah. I think we agree.
Yes.
Maybe if I can add up to this, maybe just to touch upon the part of your question that goes towards how do Article 86, so right to explainability under the AI Act, and Article 22 of the GDPR interact? Well, there I think you need to be quite careful and make a case-to-case analysis, because although Article 86 AI Act only applies for high-risk systems, whereas Article 2 GDPR applies to all cases. But then again, Article 86, if I'm correct, only applies insofar as a right to explainability is not foreseen by another legislation. So then you really need to be careful to assess, should I use Article 86 or should I use Article 22 GDPR? So for that one, it's a bit tricky, I would say. Yeah.
Great. I'm going to go next to Monique, but I did want to add just a brief comment on this phrase, explainability. I'm not a big fan of it. And I think the better word is contestability.
Yeah.
And the problem with this phrase explainability is it sounds too much like rationale. This is the basis of the outcome, right? There's data sources, the reasoning, the logic, on and on it goes. The outcome may have been wrong. And so the real question becomes, what is the opportunity to contest an adverse outcome? And this takes us back, by the way, to the PNR decision, because the way the court reasoned there is that if you don't have a meaningful ability to contest an outcome, you don't have an Article 47 right of effective remedy. And I know we use this phrase explainability a lot, but I'd urge you all to kind of push back a little bit. You know, in the data privacy world, we had the infestation of sharing. Suddenly, everyone was sharing data. They weren't disclosing it, they weren't transferring it or releasing it or having it breached. It was being shared. This is not the right way to think about it. So,
And if I may add
Yes.
something to that, it's also what we need is a little bit of legal innovation, especially in administrative law, because today the situation is very terrible. You have the right to contest a specific decision that is taken mainly because of a general system. And that is disrupting the logic of the rule of law that we were using usually, where you have a law, a specific rule, general, interpreted by a judge or by someone in the administration, and then you contest the decision. That makes sense. But that you contest this specific decision only when you have a problem that is related to a system makes it very difficult for people that wants to complain to reach the goal, that is to take off the system. And there we don't have collective rights in administrative law. We don't have a way to go against the model, for instance. We can only go against the decision. And I think that there, if you are a government, an administration, and you think this is a very good model to do what you want to do, then you implement it, even if you have 5% of people that will complain, okay, the judge will decide in favor of this person, that person, but you can still run this model if it's effective, bring you enough money, whatever. And there we need more than just AI Act, etc. We need a new way to bring models to justice.
all right, so I promised to go to Monique, but this is such a critical topic. I just want to add the concrete examples of the Dutch benefits scandal,
Yeah.
where we have an AI system that improperly took people off the benefits determination. We had the British exam fiasco, yes, using proxies for outcomes. So I think it's very important as we talk about AI and decision-making that we keep in mind our ability to constantly test these outputs, which is becoming much more difficult. Okay, as promised.
Thank you. I'm Monique from CPDP. And my question is for everyone. You have like academia, civil society, private sector, and governments. How to advance fundamental rights in this simplification efforts in the UI Act, and how this can be like also affecting the GDPR strength, let's say. Thank you.
Sorry, I didn't get the question. Can you repeat it, please?
How to advance the fundamental rights, in this like simplification efforts of the UI Act.
Big question. I'm not sure that, I'm not sure the protection of fundamental rights via the AI Act can be solved by simplification of the AI Act. I think that there needs to be more clarity in relation to certain obligations in the AI Act, which would certainly go a long way to helping the protection of fundamental rights, because it will prevent future litigation, which will hold up the enforcement and the implementation of the fundamental rights protections. But from a larger perspective, I think one of the main challenges to the protection of fundamental rights is not just the AI Act, it's all of the legislation. Everything now approach to legislating technology that that is a potential threat or risk to the protection of fundamental rights. And I know that from practical experience about the choices that organizations have to make about how they implement, because there is so much to implement, and that has a cost. And so the simplification, could potentially alleviate that issue, and that might be conducive to the better protection or the achievement of the fundamental rights objectives of these important. Each piece of legislation is important. So to achieve the objectives of the different pieces of law.
Good. Thank you. I see my friend Ingrid in the back had a question.
Yeah, thank you so much, Mark. I would like to make a statement or a question about this idea, what Gregory meant about machine learning being better than humans. I think it's a strong statement, but the question is, what are the criteria? How do you measure that a machine is better than a human? And it relates also to the question of explainability and contestability. Imagine a doctor in an intensive care unit, and there is an AI system predicting an imminent death, and that it's not effective to treat the patient anymore, or to give expensive medicine or things like that. So, and the machine learning system doesn't have human experience, and I still think that human experience is still very important, because we have senses, we have other things, sensory things, we also have a life history, we have a biography and all that. And all that doesn't matter, but if an AI system predicts something, then the reversal, there is a kind of reversal of proof in saying, I want to act against this proposal or decision of a machine learning system. And I think that's a very tricky thing. And we shouldn't fall into this trap, I think, of thinking that machines are better than humans because they rely on probabilistic rationales and thinking. And I think there are individual situations where there has to be more space for human decision making, and this space is shrinking, or the humans have to give justifications to counter this AI system's decision or proposal. And I think that's very, very difficult in terms of really undermining human thinking, undermining human decision making, undermining human autonomy. It's more like, yeah, so I think just having heat maps and having something which can explain a little bit more about what an AI system took in terms of weights and things like that, it won't replace human autonomy, human responsibility and all that. So it's not just a question of numeric, automatic weights or things like that. It's more fundamental.
So, I mean, there is a philosophical discussion behind that. I think that what I'm kind of convinced is that, for instance, autopilot for flights are better, and we have a very, very huge history of being able to check, and it's better to do the landing of flights. But of course, you still, and that can be a problem, you still want that the pilot can do something when the autopilot is off. Then you want to keep some skills that people will lose when machines are better. And that is, I think, a very... And I think that is a very important societal thing, but I really believe, and we have a lot of examples with a lot of data, that for some specific decision, machine learning models are better than humans. And I have to say, I'm in favor of your claim from a philosophical perspective, but the evidence are against me.
Yeah, I would say it depends, right? Because I mean, that's the like, we cannot discuss this at a level of generality. It's always embedded in context. And I find a lot of inspiration in the work of Professor Arvind Narayanan from Princeton University, who is talking exactly about this, to what purposes machine learning can be helpful and where it absolutely should not be used. And he makes this point that perhaps some systems might be helpful in pattern recognition in images that can help, detect cancer. But when we apply machine learning in prediction of human behavior, in complex societal issues and situations, then he says we absolutely should not be using machine learning for this purpose. So I think, to me, we cannot really discuss this in such a general manner, and yeah, I would recommend really checking out his work because I find it very inspiring in this context.
I'm a big fan of Arvind's. That's AI Snake Oil, by the way, is his book, and he has a great mailing list as well. Okay, well, I think this is a good place to wrap up, and I want to thank you all for making it till the end of the day. I know it's been a long day, but it's been a very good conversation. I want to thank our panelists for the excellent participation. If I could add just one or two final points, also a bit of an advertisement. If you're interested in the field of AI policy, we offer online courses in AI governance, and if you use the search phrase AI Policy Clinic, I think you'll find our courses. We're taking applications till mid-June for the fall. There's no charge, but there are a lot of people very interested. And then, speaking of language, there's one other pet peeve I have, which is this phrase, human in the loop, and I don't particularly like it. I think we need, instead of human in the loop, we need humans in charge, and computers in the loop maybe subject to an a priori impact assessment and ongoing review throughout the life cycle. I think we need to think about AI governance as people remaining in charge for the decisions that are made and the deployments that are taken. And there's no necessary reason to assume that AI is a part of this process. That's also a decision that we get to make. So thank you all again for participating, and also hope to see you tomorrow evening for our cocktail and awards presentation.